Hello everyone, my name is Navnee Gulati. Today in this video I'm going to talk about a very important matrimonial liberty which we all have, and it is enshrined in section 9 of Hindu Marriage Act. Yes, I'm talking about restitution of conjugal rights. Restitution of conjugal rights is mentioned in section 9 of Hindu Marriage Act. So first, I will give you a broad overview about what is restitution of conjugal rights before going further into the details. Suppose husband and wife are living together, and one day wife suddenly leaves the house of her matrimonial home without giving any reasonable cause. वाइफ हस्बैंड को छोड़कर चली जाती है अपने मैट्रिमोनियल होम से कोई भी रीजन दिए बिना. Then the husband may approach the court and ask for the decree of restitution of conjugal rights. And it can either happen vice versa. Husband चला जाता है matrimonial home को छोड़कर, तो wife can go to court, and if court is satisfied, then the court can give a decree of restitution of conjugal rights. That is the decree to come back and stay in matrimonial home and stay with all the conjugal rights and the matrimonial rights which were prevailing. So what the section states, now I will be reading the section and I will read it in two parts and make you understand in the minute details of the section and how the section works. And let's start. Section 9 states that when either the husband or wife has, without reasonable cause, withdrawn from the society of other, the aggrieved party may apply petition to district court for restitution of conjugal rights. या तो husband या wife बिना किसी reasonable ground के, अब reasonable ground क्या होता है? Reasonable ground can either be like, अगर wife कहे I have a job in some other state and I am not intentionally leaving my matrimonial home and I am not going away intentionally from my conjugal rights, then it is a reasonable cause. तो अगर कोई reasonable cause नहीं है husband और wife के पास and they are leaving from the society of other person, what that means? Society of other means the matrimonial relationship, the matrimonial duties and the conjugal rights which were prevailing in the society, they are leaving from that. So that means the aggrieved party may apply petition to district court. The aggrieved party, या husband या wife, दोनों में से कोई, they can apply to district court the petition for the restitution of conjugal rights. The second part states that, and the court, on being satisfied with the truth of statements made in such petition and that there is no legal ground why application should not be granted, may decree the restitution of conjugal rights accordingly. तो दूसरा पार्ट इस सेक्शन ये कहता है, अगर कोर्ट सेटिस्फाई हो जाता है जो भी स्टेटमेंट पिटिशनर ने दिया दैट आर ट्रू एंड देयर इज नो लीगल ग्राउंड, कोई भी लीगल ग्राउंड नहीं है ऐसा जिससे हम पिटिशन को कैंसिल कर सकते हैं, तो कोर्ट may decree, कोर्ट either can refuse it and can decree for the restitution of conjugal rights. So court has the discretion to give the decree, and the decree is given under Order 22 Rule 32 of Criminal Procedure Code. तो मोटी मोटी तीन बातें हैं इस सेक्शन में which we all want to know and which we all should know. That is, without giving any reasonable cause, one spouse is leaving or withdrawing from the society of other. एक कोई भी reasonable cause नहीं है and they are withdrawing from the society, they are withdrawing from the matrimonial duties, conjugal rights without any reasonable cause. ये पहला point. Second point which is to be noted is, court is satisfied that the allegations which are made are true and there are reasonable grounds जिससे ये prove हो सकता है, ठीक है? And the third point is, there is no legal ground when petition should not be allowed. कोई भी ऐसा लीगल ग्राउंड नहीं है जिसकी वजह से दिस पिटिशन कैन बी डिसमिस्ड. सो इफ दीज थ्री कंडीशंस आर फुलफिल्ड, then the section is complete and the petitioner can seek for restitution of conjugal rights. So coming forward in this section, a very important point which I would like to discuss and talk about through this video is a court may decree one of the spouse to restitute for the restitution of conjugal rights. बट सपोज अगर हस्बैंड अपनी वाइफ को छोड़ के चला जाता है या लेट्स से वाइफ अपने हस्बैंड को छोड़ के चली जाती है एंड दे आर डूइंग इट विलिंगली एंड दे आर नॉट रेडी टू टाई the knots, they are not ready to live in the society of other person, not tie the knots actually, then the court passes the decree of restitution of conjugal rights and they are bound to live in the society of other persons by the purview of that decree, and they are bound to have the conjugal rights, and conjugal rights include physical relationship between the husband and wife, which is a very essential part of marriage. But if the other person is not willing to maintain it, then don't you all think that it is violative of Article 21 of our Constitution? Personal life and liberty is enshrined in Constitution through Article 21. So don't you think that it is violative? If wife doesn't want to live with husband, doesn't want to cohabitate with him, then is it not violative of Article 21, the decree which is passed through Section 9 of Hindu Marriage Act? So the same question arose in the case of T. Sarita versus Venkata Subhaya. In this case, the constitution validity of Section 9 was challenged in Andhra Pradesh High Court, and Andhra Pradesh High Court took the same view and stated that Article 9 is violative of Article 21, 19 and 14 of Indian Constitution, because this decree takes the autonomy of person's body from himself. अपनी body की autonomy ही चली जाती है through a decree. You are bound to live with that person and maintain a relationship, and that to maintain and cohabitate with that person, not willingly, or you can say forcefully, through a decree. So the court stated it to be violative of Article 19, 14 and 21. Then 1 year later, another case came in front of court, which was Harvinder Kaur versus Harminder Singh. In this case, the same question arose and the court threw more light upon this question, and court stated that we cannot mix constitution law with Hindu Marriage Act in these cases, because it would be like introducing a bull in a china shop. किसी सांड को हमने चाइना शॉप में भेज दिया, ऐसा हो जाएगा. So the court says that restitution of conjugal right is not limited to only maintaining a sexual relationship, or not maintaining with the physical relationships or marriage, not maintaining only conjugal rights of the marriage, but it is cohabitating together, and it is a reconciliation of marriage. In Hindu marriage, marriage is very sacred, and the court performs and tries its best to save the marriage and save the very essence of matrimonial rights and the matrimonial promises that are made. So the court has the duty to perform and save the marriage. So this is not violative of Article 19, 20 or 21 or 14, but it is a way of reconciliation. So the court threw some more light and say we cannot in this case mix the both. So for today's video, I will be talking about this only. I hope it gave you some light about this section and the remedy which is available in Section 9. Thank you for watching my video, guys.